Okay, in our last video, we started talking about Richmond versus Crozon, and we know that the compelling interest in an employment type of affirmative action case based on ethnicity, the compelling interest would be remedying passive participation in your own history of in your own jurisdiction's history of past discrimination. Now, why does this work? I can't go into court. I've never done this before, and I don't think I ever will, and I don't think any good lawyer ever would go into court and say, Your Honor, here's my client, the biggest slime you ever met, right? The worst actor you've ever had in your courtroom. Here are all the things my client has done wrong. Here's all the reasons my client is liable. Blah, 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 blah. You can't do it. Because lawyers are not in the habit of making their own clients out to be the bad guy in a case. You want your client to be the good guy. Not to be gender specific, I'm talking generically, the good guy. So, instead of going into court and saying, this is what the court's telling us here, instead of going into court and saying, my client is a slime, you can go into court and say something like this. Your Honor, we have a compelling interest in remedying a history in our jurisdiction of past discrimination against, in this case, African Americans. And here's the argument you make. Everybody in Richmond knows, everybody who's in this community knows that, in particular in the construction industry, there is rampant discrimination against African Americans. So far so good. Everybody knows that. My client, the City Council of Richmond, being a part of everybody right in the community, is aware of the history of past discrimination in the construction industry. So I'm not saying the City Council discriminated. I'm not saying the city itself discriminated. See what I'm doing here? I'm saying that we knew, everybody knew, that there was discrimination going on in the construction business. It's on them, right? It's in the community, but it's not the government itself that's being exposed here to some kind of liability. So the City Council is aware of this history of discrimination, and here you go. You say to the judge, and this has gone on long enough. The City Council has decided enough is enough, and it is time to do something about it. Okay. So now, the City Council is not the bad guy. Now the City Council is the good guy, right? That is trying to remedy a history of discrimination that was limited to your jurisdiction. Look how this works, right? It's limited to our jurisdiction, but it wasn't active discrimination by the city itself. It was passive participation. Right? Passive means you're on the sidelines watching it happen. And what you'd be saying now is, and now finally we're going to get off the sidelines and try to do something about it. So that's why that standard works for lawyers, because you can use that standard to litigate and to advocate in a way that does not undermine your client's chances of winning and does not expose your client to liability. You'll notice now on our grid we have 3 squares filled in. Right, this sounds like a game show. Under higher ed, you have diversity in higher education as your compelling interest, and you have reaching critical mass at a mere plus, right, an individualized review of applications. That is your means, the narrowly tailored means. Over on the employment side, you have 1 block filled in, and that's the compelling interest. The compelling interest is you are a passive participant in a history of discrimination within your jurisdiction, and you seek to remedy that. That's the interest, remedying, right, past history of discrimination in this jurisdiction, the city or the government being a passive participant. What we don't have yet filled in is the box about what are the narrowly tailored means in an employment case. Here. The best I can do is describe some lower court cases and some scholarship on this. Courts have been a little bit all over the map on this. Now, the reason that box is blank when we look at the Supreme Court's cases is look what happened in Richmond versus Crozon. The court said, and this is the case, the Supreme Court case about public employment affirmative action programs. And what the court said in this case is Richmond has no compelling interest here because it's got Eskimos in its program, right? And has no compelling interest in remedying a history of discrimination against Eskimos. That's not what's been going on in this jurisdiction. So, having said there's no compelling interest, the court never got to were the means narrowly tailored. It never told us how to narrowly tailor the means in an employment case. There are cases where federal courts have upheld specific numbers in these, but here, think about being a good lawyer. In most cases, when a jurisdiction wants to have an employment type of affirmative action program, lawyers are going to be careful to try to hew as closely as possible to what the court said in the Michigan cases, because you can borrow some from the education cases. What do students, right, university students or law school students and employees have in common? What they have in common is they apply, right? There's an application process. You apply for a seat or, in a school, or you apply for a job. So you can sort of cross over to the education cases and borrow some and say, look, we're not trying to achieve a specific number. In some of these cases, courts talk about rough proportionality, right? You're trying to hire, let's say, a police force or any, again, any public employment or contracting that looks or reflects the ethnic makeup of the jurisdiction you're in. And so, you're trying to, I'd be saying, I'm not trying to reach any specific number, but I'm trying to reach some level of proportionality. That's not ridiculous in terms of underrepresentation of minority groups in public employment. So that's one way to stay away from numbers. And another thing you can borrow from the education cases is the mere plus, right? To say somebody's ethnic status is not an outcome determinative factor in hiring or letting a contract. But basically what you do is this. You say, let's say we have two contracts. And when anybody out there who's done some work on public contracts knows that there's often a bidding process. Different jurisdictions have different rules about what bids they have to accept. But if you're in a jurisdiction that allows affirmative action, on your bidding forms, right, you would just put a box. If the majority ownership of your business fits into the following ethnic categories, check the box. Or one of the ethnic categories, check the box. And then you look at your bids and you can say, okay, if we, one is a little higher in price, but the other one's a little higher quality. One has better references, but the other one's going to be a week ahead, right, of this one. You look at these and you say, they're roughly. There's a little bit of give and take here and there, but they're roughly equivalent in terms of their quality under our standards and our criteria. And so you look at that and say, so if these two are roughly equivalent bids, and one is a minority owned business, then we pick the minority owned business. Again, not as the outcome determinative factor, but as a factor that tipped the balance slightly in favor of one bid or one applicant over another. So, to review very quickly all of the boxes on your grid. On the higher ed side, compelling interest is diversity in higher education. The narrowly tailored means would be you are trying to reach critical mass by considering ethnicity a mere plus with roughly equivalent applicants, and you do an individualized review of every application. On the employment side, your compelling interest is remedy a past history of discrimination in your jurisdiction as a passive participant. And the narrowly tailored means to stay safe, you would want to avoid numbers to the extent possible, shoot for some kind of rough proportionality based on the population of your community. And you would borrow the mere plus type of a paradigm to try to convince a court that the means are narrowly tailored. They're not too broad. They're not, you're not throwing out numbers or standards that would invite a court to second guess you. So that's a wrap on affirmative action programs. We will next take up the issue of gender. Again, we'll talk about this a little bit in our live session, but we will move on to gender and other classifications and continue on our march through the Equal Protection Clause.